Rob Henneke, it's great to speak with you.
Thank you. Same with you.
So, Rob, you are the lead counsel on this case about the Affordable Care Act, which we've been hearing a lot about during these first few days of the confirmation hearings of Amy Coney Barrett. A lot of Americans are, frankly, very concerned about affordable health care. I think this is probably a big reason why this is coming up so much, but I wanted to get your take. Why is it that you think this issue is so prominent in these hearings?
I think the issue is still prominent because 10 years after the fact, the Democrats who passed this as the signature piece of achievement under the Obama administration are still trying to convince the American people that the Affordable Care Act is good policy when in fact it's failed. Not only is the law unconstitutional, but the irony of the Affordable Care Act is that it has caused health care to not be affordable, as premiums have more than doubled, as people have lost the choice of their doctor. And so here this week, we're seeing Democrats still trying to convince the American people that the Affordable Care Act works when we as Americans know that it does not.
How possible is it that you would actually be making arguments, assuming that Judge Amy Coney Barrett is confirmed in front of her?
Well, the Supreme Court recently announced that, in fact, there will not be in-person arguments for the remainder of the year. The Supreme Court is having telephonic arguments. In this case, I represent the individual plaintiffs that have joined the case. We're co-plaintiffs with the coalition led by the state of Texas. Unfortunately, because the Supreme Court rules only allow for one attorney to argue per side, the Texas Solicitor General will be conducting the argument, representing the side that I'm on. But certainly, we're fully involved in the case and excited to have our issues presented to the Supreme Court.
It's not necessarily obvious. Okay, there are plenty of issues that would be fair games in a confirmation hearing of this nature, obviously. But there has been this inordinate focus on the Affordable Care Act. I mean, in comparison to, say, something like Roe versus Wade, which is another, question that has been brought up a lot around the confirmations of Judge Barrett, the confirmation hearing of Judge Barrett. So what are your thoughts about why this very particular focus here at this time?
Not only are Democrats trying to still make the case for the Affordable Care Act, but obviously politics is coming into play here in these confirmation hearings. I think the Democrats are still working off of their playbook from 2018, where they very successfully used the fear-mongering over the elimination of the Affordable Care Act to retake the House of Representatives and to achieve other gains through the election process. The difference then is in 2018, Republicans had just failed, where the Republicans had the House, the Senate, and the White House, and had failed to achieve any reforms in terms of health care. Whereas now in 2020, President Trump actually has a pretty robust package of reforms that he has accomplished that are actually being successful in allowing people to have more empowerment over their health care at more affordable rates.
There have been a number of challenges at the Supreme Court to the Affordable Care Act. The last one, Sebelius, I believe, I hope I'm pronouncing that correctly, actually found that the whole act was constitutional, from what I understand. Now, what makes your case right now different and significant?
Well, the case you're referring to, NFIB Sebelius, actually struck down a major provision in the Affordable Care Act when the court held it was unconstitutional for the government to require states to participate in the Affordable Care Act. So that provision was struck down. But, the remainder of the act was able to survive because at the time, the federal government assessed a penalty for persons who did not comply with the individual mandate's command for them to buy the health insurance that was required by the government. And the court held that because this penalty existed, that they could construe that as an exercise of taxation power. But otherwise, Chief Justice Roberts did hold in his opinion that by itself, this individual mandate command would be unconstitutional. Now, in 2017, Congress eliminated the penalty through the Tax Cuts and Jobs Act. So where our case comes from is taking directly from the language of Chief Justice Roberts in his opinion to now come back to the standalone individual mandate as being prohibited by the Constitution of the United States.
Fascinating. Well, so for a lot of Americans right now, obviously healthcare in particular, as we're experiencing coronavirus, I don't know which month we're in right now, but many, many months into it, it's a huge question for people. And as we discussed a little bit earlier, this is being portrayed to some extent as if Judge Amy Coney Barrett is confirmed onto the Supreme Court, affordable health care could be eliminated. Your thoughts?
Affordable health care has already been eliminated. Here today in the United States, 10 years after the passage of the Affordable Care Act, you today have over 15 million Americans who would qualify for health insurance for themselves at no cost and choose to be in a state of being uninsured because health insurance does not deliver value, does not give them access to care. Even more so than that, many Americans know that under Obamacare, many of the health insurance plans today are expensive and carry high deductibles that require most Americans to still pay out of pocket for their health care despite having insurance that doesn't actually give them access to the doctor. So affordability is actually one of the issues that 2/3 of Americans cite to about their dissatisfaction with the current healthcare system. And it's certainly the driving reason for why many Americans are not able today in order to access care. The care exists, they just can't afford to pay for it, and so they have to go without.
What do you expect the impact of potentially having an originalist such as Judge Barrett on the court would be for your case?
It's going to be very good for the case because a textualist like Judge Barrett, as she's testified in this week's committee hearings, is driven by the text of the statute. And the central question, or the main question at issue in the argument next month over this constitutional challenge to the Affordable Care Act is the question of severability. When the individual mandate is struck down as being unconstitutional, does all of the ACA have to fail, or can certain parts be severed off and salvaged? But under the test for severability, first of all, the statute controls. And Judge Barrett has testified that this is important to her as a textualist. So I think that she's going to find it very important that in many places, the Affordable Care Act describes the individual mandate as, quote, essential. And that is Congress's way of telling courts that this is not a provision that you can just separate off and strike down by itself.
So let's say the Affordable Care Act as a whole were struck down as you're describing. Again, there's a lot of fear around this happening, right, among some Americans, certainly.
And I think some of that fear is fear-mongering that's been driven by the left. Look, the healthcare system in our country, albeit far from perfect, did exist prior to the passage of the Affordable Care Act. Private insurance companies existed prior to the Affordable Care Act. If the Affordable Care Act vanished today, people that have private health insurance would still have private health insurance. People who access their health care through Medicare, which is a federal government program, would still have Medicare, would still have Medicaid. What would happen overnight, though, would be that costs would come down when Americans would find themselves free from the regulations of the Affordable Care Act, and in fact then be able to go out into the marketplace to purchase health insurance that actually meets their needs, and to have competition that would force down prices. So the protections that exist today, the coverage that people have, would continue. States would be able, in the interim, to be able to adopt additional consumer protections. But really, the benefit would be to bring empowerment back to the American citizen to have more control and say in their healthcare choices, rather than those decisions being made by a bureaucrat in Washington, D.C., or a bureaucrat in a big insurance company.
Well, and so again, the contention would be that there's a group of people in the prior system that are kind of left behind, that don't have access, and that's a huge problem.
Well, 10 years after the passage of the Affordable Care Act, the people who today still don't have access to health care are victims of the failed policy of the Affordable Care Act. This was the law that was promised by President Obama to not only decrease costs, but to give universal access to care. There are still today many problems with our healthcare system, and those are being driven by the Affordable Care Act. But look, states and Congress have an obligation to do better. And so they shouldn't wait until the court rules, but rather should get to work today to make sure that there's a safety net for people with chronic conditions who aren't able to be insured, and to also make sure that people have the personal freedom to be able to make healthcare decisions for themselves and to restore that doctor-patient relationship. They don't have to wait for the Supreme Court to rule. They could start working on that today.
So Rob, what is your biggest objection ultimately with the Affordable Care Act?
I think it's important to know about this upcoming Supreme Court argument, to recognize that the Affordable Care Act was a 2,000-page bill. And, some of the critics, question whether the Supreme Court would strike down the entire law. But I think what's important to note is that while there are some consumer protections that may survive, the very central concept of the Affordable Care Act, the reason why Democrats and President Obama passed it in the first place, was premised upon this individual mandate, this idea that the federal government can command you to purchase a product even if you don't want it. We know that that's unconstitutional. The Supreme Court has told us so. And so even if some parts of the Affordable Care Act survive, I think it's highly likely that the very engine of Obamacare will be struck down, and that's going to be good for Americans because that's going to free them up to be able to regain control over their health care.
Any final thoughts before we finish up?
We're looking forward to having Judge Barrett on the court. I've been very impressed with her this week, with her amazing command of the law, with her demeanor, with the way that she's approached and responded to some very pointed questions from Republicans and Democrats on the committee. I think she's going to add a great perspective, and her commitment to the text and the rule of law makes me highly confident that when she's on the court, her decisions are not going to be based upon her personal feelings, but really be driven by what the law tells her. And that's really what we should expect from the judiciary. So I think she's a credit to the legal profession. She seems to be an amazing woman, and I certainly wish her the best in her confirmation and look forward to her service on the court.
Rob Henneke, such a pleasure to have you on.
Thank you for having me.